Your guy's Kruger, correct?
Yes, actually, I guess I need to get appointed to it. Can you put me on there? Yeah, whatever the new case is. It's from 2021. Apparently it was under seal. I don't even know what it is.
All right, is it this one?
Nancy, I'm sorry. No, because this would have been indicted this year. It just got
Okay.
unsealed like a week ago,
Ah, okay.
maybe 2 weeks ago.
All right. Well, they may or may not have this.
You already have it? No, he has 3 cases. The one that we're looking for is a 2024 CR number. Yeah, let's take a look.
Okay.
Yeah. What's happening? Hey, what are you doing, man? Sure. Oh, yeah.
I did,
They're never, they're never going to change that filter out there. See? Hey, was your client crying? Yeah. Just like. All right. Carlos Terrazas.
Here, Rochelle had come by earlier on this one, and then she had to go take care of some things off-site. He is awaiting an insanity evaluation.
Mhm.
It's set Tuesday, and I think Rochelle's trying to find some wiggle room for some cases she has pending, so we were hoping that ahead of time we could get it bumped, since he's still awaiting the insanity review.
All right, what's the status on that?
I believe everything on our end is done. I think we're either awaiting the results or the actual review, but as far as like having to go with Carruthers, my understanding is all is done.
Okay. Norma? What's the time frame on the sanity evaluation?
It's 2023 CR 4176.
If I did though, they're gonna send Kruger down to not have a, I'll just get a reset. It's the newness of the call. And don't jump on the system, they'll ask for 10. 10,000, I mean. 'Cause I don't know.
All right, so on Kruger,
Yes, Your Honor.
what time are you asking for?
If I can have, honestly, it shouldn't take me that long. I'm gonna say a month just to get up to speed on whatever this new case is.
All right, Ms. Ferguson, on Kruger, I need a 30-day reset.
And I need to get appointed on the new one. That would be probably a good thing to do too.
All right, so we'll see you back on April 30th.
April 3rd. Take your time. She's wearing the April. It's the same. Tears flying by.
Okay. All right, who do you have?
Judge, I have Jesus Trevino. The file should be up there.
All right, is he in custody?
He's in custody. We previously filed a motion for competency eval on the 23rd of January. We're still waiting.
All right. You say on January 23rd?
Yes, January 23rd, 24 filed.
All right, Ms. Ferguson, check with them and see what's the holdup on this competency eval. All right, so it's done. So we're just waiting for the report?
Yeah.
All right, let's recall it in 30 days.
Thank you, Judge.
All right, you're welcome.
Yes. A lot of times, yeah.
Okay, thank you, sir.
Thank you. Yes, sir.
Taking no prisoners.
I can do coffee and I'll go to all that stuff.
Tell them we got patience in our pockets. It's Friday's Eve.
Pretty serious shit like that, Robin. Very serious. The other guy stabbed, so. You know, he was incompetent. 5 years. Hey, Sean. Hey, absolutely. I definitely. I was in 227.
Okay.
I felt bad.
So everyone, put some patience in your pocket. It's going to take the deputies a little bit of extra time to bring the inmates back up.
Dang it, Judge. If you pay them, they'll bring her in quicker.
Michael was.
Huh? Well, you know, talk to whomever is in charge of the way the court was built.
The 290th across the
Yeah.
Michael De Leon. No problem. Be
Yeah.
careful here.
Should I say something like we wouldn't have those problems here if you showed up on time?
Oh, Michael. Only one person.
Come to the 187 first.
Oof. Good old Mike.
Oh, yeah. He has the jokes.
Yes, he does.
Yes, ma'am.
Oh, it's a pen.
Oh,
Sorry.
Here's a whole one.
It looks good, but it doesn't right.
It didn't right.
Was it eyebrow pencils?
Well, it's for the iPad. Eyebrow, actually.
Eyebrow pencil.
Yeah,
Oh,
there it
is.
Yeah.
Eyebrows. Oh, that's it, that's it. Somebody's gonna get clever and come up with a nice.
Yeah, for the 2023 CR things and the nightmare, yeah. Let's see. Right here. File 123/24. No, I'm seeing something like that. Montgomery. Tribune. They keep filing.
Yes.
Can I show you a picture?
Yes.
Don't leave the bench unattended.
Okay, you need to send that to me. I think that's so cute.
Okay, I will. That's a Judge Shaw's bench, but he wasn't there at the time.
I like it.
Judge Shaw's been?
The Easter Bunny made an
Yeah,
appearance in
yeah.
his court.
How's juvenile treatment?
It was all right. I didn't like the case, but I always liked the court.
There you go. Who's he? Ready for this?
Let's see what's going on.
Good, it's very solid building.
Thanks.
Oh, is that right? Some of those thicker ones that are.
That's probably one, the one conviction, I guess.
No, so we have a cycle for sanity and the doctor and I. Actually. Oh, that's it. Oh, he made the draw. I was like, doctor, he was shooting out a wizard. I was trying to kill him.
You do federal?
Well, yeah, but he knew the shoot was.
Yeah.
They appeared and started shooting fireballs like Marley out of it. Shoot the wizard. Like, your boys are so. Yes, I know that, but a crazy person.
I don't know, similar to that.
I guess it's like I think she was about to change my strategy.
No, absolutely. No, I just says they keep saying.
With the different ones, very hard to get.
I mean, I've had it
Really?
twice in juvenile.
Yeah, juveniles a lot easier. This, the definition of juveniles is much easier. It should be what's not for that side. But because I had, original ride, or not through, what's it called, lack of responsibility. Right, yeah. So I had two that, over here, never had.
Oh, man, no.
Yeah, when he finished treatment, I want that, he's, we're on year 6, and he's a turn on, robust, everything is 2 or 3 times. So my kids actually also.
Do you have that?
Should be
Actually,
there's 4 years.
Yeah.
Oh.
I had a collection.
So 800.
I have a collection of.
Oh, no, so no, the juvenile, yeah, right. One
Where
was
they were
a third grade
and
application.
My God.
They're so comfortable, they're humane.
And they're brand new. I never heard of it. I would have to get the knockoff brand.
Golden.
Golden.
Yeah.
Call them Shelly
Yeah.
So.
I have a collection. Yeah, I love them that much.
Yeah,
I mean, I want to spend money on
He's facing the
it.
next rock.
my joke is my daughter and my money go to police.
We'll see.
Yeah, university.
Sounds like he is, he said he didn't do it, even though he's, I'm very saying, so I do.
For what?
Thank you.
Tell you what.
Yes.
They have to have it
Four
for-
pages.
It's never signed.
Well, why wasn't the order signed? Because if it would have been handed to me, it would have been signed.
She said that they're gonna have to set- To get it ordained.
All right, so where's this order that needs to be signed?
It was, he filed with the document like.
All right, can you pull it, please, in the back?
Do you want me to get both of them or just one of
Yeah,
them?
you just get both of them.
Okay, and then he picked up, well, not that he necessarily picked up, but they filed new cases. I haven't filed the motions for competency for those, but I'm
Oh, yes,
assuming.
this one is just good.
Rotator cuff?
Yeah. Say to walk on. Pulling all the habits. Yeah.
Exactly. Change. This is gonna be insane. I'm sorry. I swear I worked pretty jobs. You know what? There's a. It's another one. Oh, you penny.
I've been many more.
Sorry.
Cases that had a very good Spanish money, much.
Oh, look at that.
Here, I might have a pen.
There you go.
Yeah, I know. This is not the one, this is a different guy.
Oh, is that a family guy?
Yeah, I've already
Maybe
agreed
the
to
washers, chief little washer.
Yes, sir.
I don't, I think that may.
But yeah, that doesn't change my opinion on that.
Takes you as country, I'm not sure.
I know,
Yeah.
I didn't know if it was related.
Sure.
We just get it to sign off.
Yeah.
Okay. Would you do me a favor? No way. You know, I didn't mean that. That's stressful.
steps in.
Well, I just-
Are
you on this? Judge, may I approach?
Yes,
Just gonna go downstairs. I have an agreement off docket for a bond setting.
sure.
I'm just gonna get it approved by Judge Nahara. I'll be back on my principal case, which
All
is
right.
Arun Bawani.
All right, thank you.
Thank you, Judge.
Up to. It's like crazy, actually. Yeah, crazy.
Judge, may I approach?
Yes.
Okay, here, that's all stop. The other one that was previously a night mag has now just recently been indicted, so she put the new number. Okay, thank you, Judge.
You're
You
welcome.
want me to take it back to?
Yes. And Norma? There needs to be some report on why a document that's filed in January, I'm just receiving it in March. All right, Norma, recall this in 45 days. Okay. Yes. And where is he? All right.
Okay.
Mhm. All right, Mr. Cantu, why are you here?
I'm waiting on my attorney. Barrera Junior, he's coming from Wilson County.
No, are you on the docket today?
No, ma'am, he's just gonna approach
No,
you.
no, we don't. Here's the thing, attorneys. We're not doing this thing where people just come off docket, don't tell the court you're off docket, and then leapfrogging everybody. So he needs to set it on the docket, and then the court will hear it.
Thank you.
You're welcome. Diana, he shows up here every day and he doesn't have a court date set. Yes. Anthony Wardington. All right, we're waiting for your attorney. Riot Aguilar. Yes. All right, I called it. Well, I mean, I'm calling the case.
Okay. I thought you were going through the doc.
No,
I was talking to Adam about
That's okay.
some law stuff.
all right, so are you requesting a jury trial?
Your Honor, my client has filed a motion to have me dismissed and have a new attorney appointed on the case.
All right, I'm not going to do that. So today is your plea deadline date. Do you want a jury trial?
I need to talk to him, and I wanted to present that to the court first.
Okay.
Before it happened.
All righty.
And there is a file on his habeas corpus, which I have incorporated into my filing, that hearing on his time he was in jail too long.
All right, so do you all want to see if you all want a jury trial date, then confer?
Okay, I wanted
All
to
right.
bring that to the court's attention. So it's not important.
All right, thank you. Riot Aguilar. All right. George Cantu. Is the attorney here for George Cantu? All right, come on down. Court is calling. Counsel, you're on this side, your client's in the center. And you all act as though y'all trying to buy Diana's equipment. Court is calling 2024 CR 0411 State of Texas versus George Cantu. Can I have the parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defend.
Alfredo Ortiz for the defendant, George Cantu, Your Honor.
Are you Mr. Cantu?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
All right, as a habitual?
Yes, sir.
And so this tampering with electronic monitoring device, what is that, a third degree?
It should be state jail, though.
Okay,
I was looking into it. I know that the statute does have the third degree language, but
Mhm.
that's it. It was a intensive supervision. There was no language like that in our side.
okay. All right. I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes,
Did
ma'am.
you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with tampering with an electronic monitoring device under intense supervision? That's a
Yes, ma'am.
state jail felony, the way it's been indicted.
Yes,
The
ma'am.
range of punishment normally would be anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, you can unfold your arms. You get people nervous when you do that, okay? If the state is able to prove up the enhancement allegations, then this would be a second degree punishment. The range of punishment would be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he is.
Mr. Kantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney and did you understand it? According to the plea, punishment is to be assessed at 5 years in the prison. You agree that you've been convicted of 1 or 2 more felonies for enhancement, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there has not, Your Honor.
And did you understand that to be the plea, a cap of 5 years?
That's correct.
All right. And state, is that the plea, the cap of 5 years?
Yes, yeah.
All right. And to correct the record, the plea offer is for a cap of 5 years in the prison. Did you understand?
Yes, ma'am.
All right. And to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State any evidence?
State offer states to the one in all fashions.
Any
No.
objection?
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. And with regards to the both paragraphs of the habitual offender enhancement allegation, how do you plead, true or not true?
True.
And that's true to both of the enhancements?
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. Do y'all wish to proceed with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. We filed a motion to reduce this state of jail felony to a misdemeanor punishment, Your Honor, 1244A. We want the court to consider the circumstances regarding the offense, Your Honor. November 7th of last year, Mr. Kantu informed his parole officer that he had problems at home, and that he was living with mom and he couldn't stay there no more. So he informed his parole officer that he was gonna take off, unbuckle his GPS monitor, that he couldn't stay there no more. That was November the 7th. He left the equipment there at his mom's house and that was not damaged or anything. 10 days later, November 17th, he self-surrendered to the parole officer. And he was taken to custody and taken to the Bexar County Jail, where he has been there since he was arrested, Your Honor. I want the court to consider that he is not a violent person. He has the criminal history that he has, a lot of that can be attributed to his drug abuse illness. He has never received any any treatment for that, Your Honor. So we're asking the court to consider all these factors and sentencing Mr. Kantu, Your Honor, and sentence him to a year in the county jail, Your Honor. And I think Mr. Kantu likes to address the court.
All right, so legally, this cannot be a 1244. So you want to raise, I'm sorry, you're already under oath. So it says in the police report that the device was removed on November 7th, 2023. And it was reported as being removed on November 8th. And when I say reported, that's not you reporting it. That's just parole became aware. So what would you like to say?
Well, I took the monitor off on the 7th, and the warrant was an issue, I think, to the 8th, the next day.
Okay. And did you turn yourself in on the 7th?
Yes, no, 17.
All right. Any questions?
What do you like to say to the judge regarding sentencing?
I mean, I just got a real drug problem, a bad drug problem, and it really needs help, you know.
Is that why your mom didn't want you living with her anymore?
Yes, doing drugs.
Okay.
I'll pass the witness.
Nothing to say, Judge, just sorry.
All right. Well, what I can tell you is I've done parole hearings in my past as well. And I know, and you correct me if I'm wrong, all you have to do is pick up the phone and call your parole officer. And in actuality, I think parole is easier than state probation. So did you pick up the phone and call your parole officer and say, I'm in the throes of my addiction. I need inpatient treatment?
No, ma'am.
Did you call them at all, telling them that you needed help?
No, ma'am. Called them after, cut it off.
Okay. All right. This is what the court is going to do. The court is going to find you guilty. Court is finding the enhancements true. The court is going to sentence you to 5 years in the prison, give you credit for any time served, and this will run concurrent with parole. Showing you what's entitled defendant's rights. I'm sorry, trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So I want to let you know that I did listen to your attorney's argument. I always internalize what I'm hearing, but at some point you got to be responsible for your actions. You understand? All right, good luck to you.
Thank you.
You're welcome. All right, who's here for Amaya Lewis? All right, where's Miss Lewis? Okay, once they bring her out, we'll take you up. You're welcome. Who is here for Albert Bishop?
All
right, where's Mr. Bishop?
He's in the box right there.
Come on down, Mr. Bishop.
Come on down. Here.
And probation, this is an application. Court is calling 2024 CR 1174, State of Texas versus Albert A. Bishop. Could I have parties announced for the record for the state?
Jason Garrett, hand your off.
Defense?
Charles Gold for Mr. Bishop.
And are you Mr. Bishop?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Bishop, I'm showing you what's entitled application for community supervision or deferred adjudication. Did you review that with your attorney?
Yes,
Did
ma'am.
you understand it and did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
You already know.
Mr. Bishop, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of stalking? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial?
Yes,
A
ma'am.
right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that I'm sorry. Did you understand by entering this plea, you were giving up those rights?
I believe, yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I think he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Bishop, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I believe so.
Well, I mean, either you are or you're
Yes,
not.
ma'am. Yes, ma'am. Sorry.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 727710. There's to be no contact with Tricia Robles, and you're not to be within 500 feet of Tricia Robles, and you're not to go to McDonald's at 101 Alamo Plaza and be within 500 feet of that location.
Yes, ma'am.
Did you understand?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
That is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 7 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Tricia Robles or McDonald's at 101 Alamo Plaza. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State Exhibit 4 with all its attachments.
No objections, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate
Yes,
places?
ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. I would like to address the court about the fine.
Yes.
He's homeless. We would ask that you probate the fine, all of the fine, until he gets a job or gets set up. We would ask, since he's been homeless.
All right, why are you homeless?
doing things for my community, the homeless community, being an activist and prevent.
No. Why don't you have a place to stay?
I guess for people's sake that I don't like being a burden to anybody.
No, I mean, if you get a job,
I
no,
know.
here's the thing, listen,
Yes, ma'am. Yes, ma'am.
if you get employment and get an apartment and pay the monthly fee for the apartment, guess what? You're not a burden. It's a business transaction. So why are you not engaging in business transactions for a place to live?
I have no excuses to give you. I'm in the process of getting that together.
So why are you homeless? Like, when does this start? Have you always been homeless?
The point of beginning to now, I've been homeless for about 3 years.
Okay, so what were you doing before you became homeless?
Couch surfing.
All right, so why don't you have a place to stay? I still don't understand why you're homeless.
I have no excuses to give you, and I present them to you. And I will now I do have a reason, a purpose to stay off probation, to pay for myself, meaning invest in myself.
Okay, counsel, do you know why he's homeless? I mean, sometimes people are homeless because they start using drugs and people are just done and they say,
I think during the time, Judge, no, not necessarily.
I've been sober for about going on my 13th year. I've never done heroin. I probably smoke weed for my anxiety. Because I do have bad anxiety. A drug problem. I'm too poor to have a drug problem. not to make fun or anything.
Yeah.
I just don't have the money to invest into a drug.
So I'm trying to figure out, how can he do well on probation? What is his plan?
To get myself on the ball for probation.
But
And
how are you going to do that?
getting a job, if it even means for right now, getting paid on,
Didn't you say something about Haven for Hope?
yeah, Haven for Hope, or the means to an end to get a job. I mean, that should be easy.
All
A
right,
purpose? Well, I had no purpose. I had no family to speak of, no kids to speak of, nobody to take care of. And when it comes to investing in myself, well, now I have a reason. So if you give me a chance, of course I'm gonna do what's right. I always do what's right.
all right, so here's the thing. No less than 2 times, this person at McDonald's said that you've been bothering her and she doesn't want you there anymore. Is GPS appropriate in this case?
At least initially it should be, Your Honor.
I don't know about that, Judge. I think wasn't this followed at large and there was nothing going on at the time?
No, I really get, every time she says the name, I really can't picture who the person she's kicking.
Well, it's the person where you keep going to McDonald's at 101 Alamo Plaza. She said you were trespassing. She didn't want you there. And it says, victim advised that the same patterns of malicious behaviors were directed towards victim by suspect. That's you.
Yes, ma'am.
They're saying that you would criminally trespass from the restaurant and would typically direct these gestures at her through a large store front window from the sidewalk. These behaviors occur several times a month and cause her to feel unsafe and anxiety. And then that was in August, and you also have the one from October. So I think he needs to be on GPS. How old are you?
20, I'm about to be 52, man.
Yes.
If I really don't need to be on GPS because I really don't have nothing bad against her. She's a manager at McDonald's. Maybe I flicked somebody off through the window that was in there, but really.
All right. See, why are you telling me that she's the manager at McDonald's and you just
Well,
told counsel you don't even know who she is?
Well, I don't know who she is personally to say, but I know after speaking to her, when she gave me, well, yeah, she's the one of the managers at McDonald's.
Judge, I just think that, I mean, we could delve into this, but I think that he's homeless, and I think I'm asking about the fine. And if we can waive that, and I don't think how he's gonna pay for GPS. I think that can graduate if we need that later on, but there's been times when it hasn't. I say he's gonna be watched over for a while.
He needs GPS. I mean, I understand the situation that people are homeless. I do. But that doesn't give everybody a pass to do whatever they want to do.
Can you give me a chance to prove myself before you put me on monitor?
No?
But then, don't I need to pay some residence for a monitor?
What I'll do is we'll see if the fees can be waived, but you need to be on GPS monitor. And we can't do a wait and see if you're gonna do well or not, because if you're back at that McDonald's, I want to know about it.
Okay.
And the only way to know about that, because you say you're homeless, is for a GPS.
So the
And do
G-
not cut off this monitor. You understand?
so the GPS is just to see if I'm in the area of the place?
Yes. What type of GPS do y'all want? Partial tracking?
None.
Oh, it's gonna be GPS.
I believe at least tracking, so that, I mean, if he is homeless, obviously, that he shouldn't be. I think the state's position is that this particular McDonald's, this particular individual was scared for her safety. And I don't know if you read in there, Judge, is that one of the times this happened, an officer was standing with this individual when it happened.
Mhm.
And so that's the brazenness of that in front of an officer is more concerning to the state also, Your Honor.
Can I speak on that?
I don't know. Does your attorney want you to speak on that? All right, it's a $1,500 fine. That'll be probated. 7 years deferred adjudication. There's to be GPS tracking. No contact with Tricia Robles. No contact with McDonald's at 101 Alamo Plaza. And you're not to be within 800 feet of McDonald. I'm sorry, you all asked for 500 feet. I think it should be 800. Any objection to it being 800 instead of 500 feet?
I wouldn't know
No
where.
problem.
Okay. And you're not to be within 800 feet of the McDonald's at 101 Alamo Plaza or Tricia Roberts. I'm sorry, Tricia Robles. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be a TAP evaluation in custody. My understanding that's 2 weeks. Follow TAP recommendations. Field visits. 1 time per month for 3 months. And then at probation's discretion. Probation, is there anything else he needs? Yes. All right, and then there's 200 hours of community service restitution. That'll be waived if you are able to get a certificate or some type of education from a trade school or somewhere else. You understand?
Yes, ma'am.
Is there anything else you need from the court to be successful?
I believe I'm being released on after monitor.
You are going to be in custody for 2 weeks for a TAP evaluation. Anything else that you need to be successful on this probation?
So I'm gonna be put back in jail for 2 more.
Yes, you are. Anything else you need to be successful on this probation?
Okay, so do I was.
Sean, you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yeah.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Partially,
All right,
So-
what don't you understand?
when I'm gonna be released.
What I told you is you're going to stay in custody
Mhm.
for the TAP evaluation. Once the TAP evaluation is done, if the TAP evaluation recommends that you go into inpatient treatment, you're going into inpatient treatment. If the TAP evaluation recommends that you be in outpatient treatment, then you will be released.
Okay, and that could be up to 2 weeks.
It depends.
Okay.
All right, thank you. Stay away from there. You understand?
Yes, ma'am.
Are the parties here in Warrington? Are you ready? Are you still reviewing things? Riot Aguilar, is the attorney here for Riot Aguilar? All right. Amanda Mahula. Is the attorney here for Amanda Mahula?
Yes, Judge.
All right, come forward, please.
Your Honor, I spoke with the state about Ms. Mahula's case.
Mhm.
They've extended an offer this morning. We're asking that the court pass the case for a plea bargain deadline. Ms. Mahula needs to get to the hospital. Her father-in-law is awaiting liver transplant surgery there.
Okay.
She's in a bit of an emotional wreck right now and can't really think or pay attention too much to the new offer. I'd like to explain it to her when perhaps she's a little less distraught.
Okay. All right. And who's getting the liver transplant?
Her father-in-law,
Okay. Is that today?
Yes.
Okay. All right. We'll recall this for April 4th.
April 4th. Yes, Your Honor.
Ms. Fergus, can you reset Ms. Mahula for April 4th?
Yes.
All right. Everything's going to turn out fine.
Thank
You have to believe that.
Thank you.
All right. Once you sign the reset form, you're excused.
Thank you.
Are the parties here on Alejo Aguirre? Joseph Balboa? Is the attorney here? Oh, come on up, Mr. Cox. All right, what is happening with Mr. Balboa?
So Judge, we'll make a lot of attempts of trying to resolve the issues before the court.
So is it a motion to revoke?
Correct, Judge, but there's a new case too in the state. I can't speak for them, but based on our discussion, they needed additional time to try to contact the complainant. Then we should be able, if that happens, there's a good chance we'll be able to resolve it. Hearing.
All right, Ms. Ferguson on Balboa, set this for a contested hearing in 2 weeks. We'll see where we're at. Okay, what date?
Give me 1 second, Judge.
Yeah. Thank you.
I think we did 11.
All right, April 11th. All right, probation is contested here on Balboa for April 11th. Alex Espinosa. Who's the attorney?
Sit down in the hallway, Judge.
Okay. Amoya Lewis. Huh? Okay, they'll bring her out. Deputy Mejia, when you get a chance. Okay, all right, thank you.
Yeah. Richard.
Richard Sosa. All right, where are we on this case?
Morning, Your Honor, or afternoon now.
And I know you were recently appointed on this.
Yes, so I got appointed in court last time. I've been pouring through discovery on it. I don't want to say we need maybe it's best just to go for a trial setting. I don't know if we necessarily need to get there.
Well, do you have all the discovery?
We have all the discovery. I do.
Okay. And was an offer tendered?
Not yet.
State, when will you be able to make an offer?
Well. So what I got told.
I mean, we could
if it's
tend
counsel,
to-
I can make an offer. It's something that they won't be accepting.
Okay,
But, it's a little different because the victims, in this case are children.
okay.
But at the time, a while back, we did speak with the guardian.
Mhm.
But now the guardian has changed. And that's what I just told Mr. LaHood, that guardian is now the biological mother. So now we're trying to go through that process, which we have not gotten a hold of her. So that's where we're at. That's why we're at this sort of dilemma at this point, Judge.
All right, then let's set it for the end of April. And we'll put that as a plea deadline date and you all can confer off docket.
Yes, yeah, I think that's fine, Judge.
All right, Ms. Ferguson, what day can we set this at the end of April? All right, April 30th.
Works.
Who is the attorney who's now Alex Cariaga?
Judge.
Ah, okay, all right,
Right now.
all right, thank you.
Yeah. I know. I mean, and I gotta talk to him once, well, I call him. You know, but I wanted to know, I mean, it's- I think a good picture of what happened.
Yeah.
I just don't know.
No, ma'am.
Yeah.
Oh, that's right.
Hit the camera. Mhm.
We'll fill out as much information as you have.
Camera's not on.
I want to keep names. Or something. Yeah, we'll see. You're good. Well, I mean, I gotta prep it anyways, so it doesn't matter. But it's easily, I really don't want to do it this weekend. Thank you so much. Every other category. Pizza strings. Yeah.
Yeah,
Judge, I'm gonna zoom real quick. I'll be right back.
Okay.
Yeah. I don't know. I probably did. Also, too. You got Mr. Ford's, CR show. Yeah.
Hello. Oh, go ahead.
Oh, no, I was just saying, I think we have an NCR resolved, Judge.
All right, thank you. Just have them pull the file and we will take it up.
It's fine. It's an agreed. I don't think we need sort of appeal or anything.
Well, depending on what I decide to do. I'm in a fair mood. All right, thank you. It's like you never know. All right, parties on Aran Bawani. All right, so today's plea deadline date.
Yes, Your Honor, and we reject all pleas.
Okay. All right, I need a jury trial date. How long are you all expecting this trial to last?
In a week, we will be flying the victim from out of state, Your Honor.
Okay. All right, I need a jury trial date. All right, you're gonna come back on June 4th for your jury trial date. Sign the reset form, and then you are excused.
Thank you, Your Honor.
All right, you're welcome. And if you all can do an acknowledgement of discovery, please.
Sure will.
Thank you. All right, anyone ready?
I think we're ready to go, Judge, on Ford. It just did the sort of appeal.
Okay. Court is calling 2021 CR 1785, State of Texas versus Ricky Ford. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Adam LaHood for the defendant, Your Honor. Are you okay? Yeah.
Yes.
Yes, ma'am, I'm sorry.
Are you Mr. Ford?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Ricky Darnell Ford who's placed on deferred adjudication in 2021 CR 1785 for the offense of aggravated assault with a deadly weapon on March 11, 2021 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 5 in Bear County, Texas, the defendant Ricky Darnell Ford, the there failed to report to the supervision officer as directed for the months of December 2023, January 2024, violation of condition number 5.
All right. How do you plead to that? True or not true?
True.
Your Honor, will waive the remaining violated conditions.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, there is. To deny the motion, continue the individual on probation for deferred, include, amend the alliance to state ISF program with cognitive, in a one time a week, for the duration of his probation, and monthly drug testing for the duration of his probation.
All right, is that the agreement?
It is, Judge. We asked the court to follow it. He was doing remarkably well. He just fell out of contact and stumbled, which happens unfortunately. We're hoping the court sees fit to give him a second chance.
All right. Probation? All right, I see on this case, there was previous McMile evaluations. So where are we on that?
What on the mental health, the mentally impaired caseload? In the 2023, the Boston Center for Healthcare Services treatment plan. However, he was discharged from that treatment in February of 2024. Unsatisfactory.
All right. Can you raise your right hand for me?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth or nothing but the truth, so help you God?
Yes, ma'am.
All right, can you lower your hand? State your name for the record.
Ricky Ford Jr.
All right. Is there a reason your eyes are not open?
I'm fine, ma'am.
All right, so yeah,
Yes, ma'am.
need to make eye contact. So were you doing well when you were on the MIC caseload and then you fell off after you were off the MIC caseload?
To be quite honest, I was doing well on probation. I was doing well, period.
Mhm.
I left here January 19, went to DDRF, finished the program there. What is it paying for? Finished the program there. I was doing well on my probation. And I lost my job and became homeless. The only thing, just to be quite honest with you, is he gave me a timeline between this time and that time to come back and see him again. But I guess we just got cross communicated. So, but yes, ma'am, I was.
So here's my question for you. You lose your job, you become homeless. Did you call probation and say, I've lost my job and I become homeless?
Yes, ma'am.
And what was the response?
Come and see me when you get a chance. And I did that as soon as I got a job, came and saw him, let him know everything he asked me to do.
So if you did everything he asked you to do, why are we here?
They put out a warrant when they told me about the warrant. The warrant was put out on February 6th. To be quite honest, I went on November, saw him in November. I wasn't supposed to see him again until February the 27th. I have that in my property in a police impound in my tote bag. If I could have grabbed that, I would have showed you. I was supposed to take a TAP test, TAPS test, but he was gonna give me a TAP evaluation. But I got that since I guess I didn't see my case manager. She the one that put out the MTR for me. Cause she told me if I didn't see her again, she said I'm gonna court you. So here I am.
Okay. All right. Do we have a tap for him or no? All right. Do you have a place to live?
Pay for hope.
All right. So this is what we're going to do. I'm going to deny the motion. Alter the amend conditions to include a TAP evaluation in custody. Follow all TAP recommendations. We can do also a referral to felony drug court. Maybe they will take him because he has the dual diagnosis. If they don't take him, then maybe lifetime recovery, because if he was in the pay it forward program, maybe lifetime recovery, their inpatient treatment will accept him. So let's do a TAP evaluation while in custody. And then let's try a referral to felony drug court. And then lifetime recovery is number 3. And then we'll do 90 sober meetings in 90 days. Oh, what's wrong with you?
I did the bees before. It was like 90 days. So it's like wrapping my head around that.
All right. Yeah. So you need to do that again. Okay.
Yes, ma'am.
And see about putting him back on the MIC caseload if he's not accepted in felony drug court.
Still on it.
Okay. All right. All right. Is there anything else?
No, ma'am.
Anything else from either side?
No, Your Honor. Thank you, ma'am.
All right. Thank you.
This
I'm sorry, I want to run downstairs and do I need to bring anything back? after we're
All right.
done?
Amoya Lewis. Hi, she's here. Amoya Lewis. All right, who is this in the blue? All right. All right, so we're still waiting for Amoya Lewis. Amoyayah Lewis. All right, who's here on Alex Espinosa? All right. Alejo Aguirre. Riot Aguilar. Anthony Warrington. All right, what is happening with Mr. Warrington?
Your Honor, I've gone over, I showed him the discovery that we have. This is the second setting. I'm asking the court for a short reset so he can decide what he wants to do. Our first setting was in February.
Okay.
When we talked to the state, and I've gone over the videos.
All right, Norma, bring this back next week because the plea deadline for this case was March 12th.
Correct.
So-
One setting on the second setting is when you
Okay.
said.
All right, so Ms. Ferguson? All right, we're going to come back on April 2nd. At that time, you need to let the court know whether or not you're accepting the state's offer.
You understand, Judge?
All right, thank
Okay.
you.
Thanks, Your Honor.
All right, you're welcome.
Yeah, can I please address the court, please?
Sure.
I'll go to, if he wants the setting on his habeas corpus, I'll go talk to them.
Okay.
Because I filed it back in January, January 29th, and then the last time I was here, you told me to go file it, and nothing's happened since then. And here we are, almost 2 months later.
Mhm.
And then some.
Right, well, I'll hear it on April 2nd. There you go.
Second? Okay, that's fine.
All right,
Okay,
Thank you.
thank you.
welcome. All right, is there anybody ready before we move on to Jesse N.O.? All right, who's the attorney on Jesse N.O.? All right, court is calling, excuse me. Y'all are gonna either need to whisper or stop talking behind the court reporter. Because we're on the record. Court is calling 2020 CR 10218, State of Texas versus Jesse N.O. Could I have parties announced for the record for the state?
Allie Jackson.
Defense?
John Reitmeyer.
And are you Mr. N.O.?
Yes, Your Honor.
All right, this is a motion for a new trial. State, have you had a chance to review the motion?
Yes, Your Honor.
All right, defense, it's your motion.
Well, Judge, we filed a motion for new trial on this matter sometime well after the verdict. By dumb luck, really, I was speaking with another attorney, and he informed me that there was a previous disclosure from the state about one of the testifying witnesses, Dr. Kellogg. I had never seen that before, and I went through everything that we had on e-discovery. Did not see any disclosures that were made to me about Dr. Kellogg. And I was informed that there is, what I saw, there was at least one, there should be more.
And what would this disclosure be?
I have it, Your Honor. I pulled it from the physical file. So it was in the physical file when we pulled it from archives, but I do concede that it was not uploaded into Verapix, so therefore it would not have been part of the discovery acknowledgement when I looked.
Okay.
So our contention is this disclosure about Dr. Kellogg relates to previous testimonies that could have proved useful to cross-examine her differently about other cases that she had testified in.
And I'm gonna provide.
All right, would you all like to mark this and have this admitted into evidence?
We would, Your Honor. We're operating this defense one.
All right, being offered into evidence for purposes of this hearing is defendant's exhibit number 1. It's a memorandum of disclosure as related to Dr. Nancy Kellogg. Is that correct, stating defense?
Yes, Your Honor.
Yes, Judge.
Okay. All right, any other evidence, defense?
No, Judge, that's it. Just argument.
All right, the court will hear argument.
Judge, our argument is simply the state had it was required under 3914, the Michael Morton Act, to provide disclosures such as that to the defense prior to trial. We did not have a chance to look at it. We didn't know anything really about it. And since it's under the state's control and custody, we had no way of obtaining it. Our argument is that affected my client's rights, and we're asking for a new trial.
State.
Yes, Your Honor, I'm providing case law. It's going to be 353 Southwest 3D 797 from the Court of Criminal Appeals. And it just lays out the prongs that you look for in this case when it's going to be a motion for a new trial for a Brady. The first prong is that the state failed to disclose evidence regardless of prosecution's good or bad faith. We do concede that it was not turned over, but when you look in the law that kind of helps talk you through it, starting on page 11, part of that first prong is that it was not disclosed, but also that the defendant could not have accessed it from other sources. In this case, this is a well-known disclosure. It's been around for years. And the first thing that you see when you Google this witness, Dr. Nancy Kellogg, as you often do when you look at an expert witness, you see multiple articles that actually provide even more information than the disclosure, both on the first page. And then if you hit news, all of the articles that are listed are about this disclosure with more details. So that's the first prong. The second prong is that the withheld evidence is favorable. We concede that, Your Honor. This would be for purposes of cross-examination. So the second prong is met. I think the first prong is shaky, but finally the third prong that must be met is that the evidence is material and that there is a reasonable probability that had the evidence been disclosed, the outcome of the trial would have been different. Now, in looking at and evaluating whether or not the outcome would have been different, you look at the entirety of the testimony that came out during trial. In this case, Dr. Kellogg was not a fact witness. She did not prove any of the elements. All of the elements, like elemental testimony, came from the victim and came from the outcry witness, Sam Abrego. Dr. Kellogg's testimony was very limited because she did not perform the SANE exam, and she testified she did not perform it. She just observed it. She testified as to what a SANE exam was. That one was performed, that there were no physical findings, and that no physical evidence was taken. All she could say was that it doesn't go against what the victim was saying, but she also could not say it definitively happened. So her testimony was not material, and the ability to cross-examine her on this would not have changed any sort of defense. The defense was always, this did not happen. The victim's lying. And that was what the defense would still be, because here the evidence showed, and she conceded, well, I can't say definitively whether it showed or not. And being cross-examined on this would continue to show and show the same defense. I can't say whether this happened or not. So because of that, while it was not given over, going through the three prongs of what a Brady violation results in any trial, we do not feel it has been met. So we would argue against a new trial.
All right, and the court will note in defendant's exhibit number 1, it does state that there was a study that was published in 2007 as it relates to any testimony that Dr. Nancy Kellogg had given. So am I correct in assuming that this disclosure has been around since 2007?
I believe it's been more since around 2013. If you look further in the disclosure, it says that in 2013, she gave an interview, or she spoke to the district attorney's office when they confronted her about that study. And it was in regards to the San Antonio report, which is what all the articles reference to. And that's when she said, I'm aware of this new study, I'm aware of the new science, and my testimony would have been different if I were to do it now.
All right, so counsel, the state has handed over a case law regarding Pena. Do you need a chance to review that?
If I could, Judge.
All right, because since we've already started the motion for new trial can be continued on a different date if you need time to
And Mr.
gather
Reitman,
case
the
law.
application of the law starts on page 11.
Yeah. So if you would like to review that and maybe come with your own case law, I can recall this.
Could we do that, Judge?
Sure. What is best for you?
Not tomorrow.
No, no, no.
I can make it work just almost any time.
All right. Do you all want to do it the week of April 1st or the week of April 8th?
Either of those work. The week of April 1st might be better for us, Judge. We
Okay.
might be less likely to be in trouble.
All right. So
That's fine. We can do that.
is Monday the 1st okay?
I can
Or
do it.
either Tuesday, the 2nd?
Tuesday is probably better for me, Judge.
All right. Ms. Ferguson, we're going to recall this for April 2nd. And then if you have any case law, if you could email it to the state.
Absolutely.
All right. Is there anything else?
Not right now, Judge.
All right, Mr. Inaho, we'll come back on April 2nd. So they're not going to transfer you. You'll be here on April 2nd, okay?
Yes, ma'am.
All right, thank you.
Thank you. Your Honor.
Diana? People were speaking fast. Norma, make sure there's a hold on him. Let me. Okay. All right. Mhm. Frankie Sandoval. Hi. Your client was accidentally sent back to the jail. Are you able to come back on April 1st? Sure.
I've been calling to work overnight that Easter.
Okay.
So if it's gonna be early, I'll come straight from work.
Okay. We'll take you up first thing. All right. Is that good for you though?
I serve with the pleasure of the court.
No, I mean, we can put it to the 2nd or the 1st.
No.
Okay.
Thank you, Judge. That way, her things can get started sooner.
Okay. All right. Thank you.
It's just if I look, that's why.
Okay. All right. Thank you so much for your patience.
Yes, maybe.
Yes. All right. This is coming back April 1st.
Yes, ma'am.
Riot Aguilar. All right. Alejo Aguirre. All right, can you call these? They're not ready.
Yes, ma'am.
Thank you. Alex Espinosa. All right.
You like the brush?
Yes. Who is the prosecutor on this? All right. Are you ready or no? Okay.
Did you have two motions in front of you and we have plea paperwork that I believe is coming through?
Oh, okay. Well,
Yeah, no, she just got it, Your Honor, and I'm,
okay. All right. Well, just have a seat. We'll get to that.
thank you, Judge.
All right, you're
just
welcome.
take a couple. Espinosa. Espinosa, he's over here. He's coming up. Oh, you were there?
Hi. All right, who are the parties on Alex Espinosa?
President, Your Honor, may we approach?
Yes.
You want to hit the middle? Make sure you keep your hand by your side. Good, that's enough. Here you go.
All right, court is calling 2023 CR 9122, State of Texas versus Alex Espinosa. Could I have parties announced for the record for the state? Defense?
Jason Todd for Mr. Espinosa.
And are you Alex Espinosa?
Yes.
Counsel, have you received all the discovery? Did you review it with your client?
I did, Your Honor. I did receive it and I did review it, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Espinosa, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, I did. I understand.
Did you review the document entitled True Bill of Indictment with your attorney? Did you
Yes.
understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Espinosa, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of evading arrest, detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
I need to speak up.
Yes, ma'am. I do understand.
All right. If you have a plea bargain agreement with the state, court does not have to follow your agreement. If for any reason the court doesn't follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Espinosa, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, there's a $500 fine. State recommends deferred. Is that what you understand the plea to be?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your term of probation be for 8 years. There be a TAP evaluation, 100 hours community service restitution, ignition interlock for half the term, DWI education or intervention. What is this? You just have DWI VIP panel.
Yeah, I don't know what we do education, Judge.
All right. So DWI education and victim impact panel. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer states that the one and all Athens.
No objection, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we just had one request regarding the conditions. Other than that, we have nothing else to say on behalf of our client.
All right, Mr. Espinosa, are you employed?
Yes, I am.
What do you do?
I'm a mechanic.
Do you have any children?
I have a son,
How old?
26.
All right. Does anybody want to speak to the length of probation?
Judge, we have negotiated extensively, and this is the offer that the state has given us, and we appreciate the deferred. This was the best offer that they had.
All right, then it'll be 8 years deferred.
The conditions wise, we're asking for the judge to not order the DWI conditions, as it's not a DWI. And it's just the principle behind it that it is innovating. He is willing, if there's other things the court wants him to do regarding community service or a fine or some other adjustment, we would understand that. And we're just asking not to have the DWI conditions.
Judge, so he was pulled over for suspicion of DWI. The officer was in the middle of the DWI investigation. That's when the defendant decided to jump in his car and drive away, where he was able to get away from the officer. He was doing that to avoid arrest for DWI. Again, that's the state's concern in adding those conditions, and that if it weren't for him jumping in the car, likely this would be a DWI case, and then this would be a misdemeanor.
All right, so I'm reading in the police report where an HGN was performed, but it doesn't say what the results were of the HGN.
Judge, just to kind of elaborate on that.
Sure.
Show the video. It does show that the officer is beginning the HGN. There is a distraction to the officer. Someone else approaches while that's being conducted, and as the officers kind of divided attention, that's where the defendant went and entered his vehicle. So he wasn't really, I don't know if the officer was able to complete the HGN test.
All right, it says I attempted to conduct the HGN multiple times on suspect 1. And once I was able to complete HGN, I continued to try to interview S1. So, I mean, in the police report, it appears that he's completed it.
That's my understanding.
So do we know the results of that or no?
No.
All right. All right. I don't have anything before me in the police report that says this was a DWI. Usually you pull somebody over, usually there's something in the police report that says he smelled of alcohol and intoxicants. I don't have that. I don't have anything. All right. So $500 fine, 8 years deferred adjudication, proof of employment within 30 days, no employment as a home health care provider with minors. Do a TAP evaluation out of custody. Follow all TAP recommendations. There should be regular reporting by Zoom or in person. There should be regular UAs, field visits, 1 time per month for 3 months. And the defensive driving course. And 200 hours of community service restitution. Probation, is there anything else? Yes, 8 years deferred. Proof of employment within 30 days. All right. Is there anything else you need from the court? Yes or no?
No.
Okay.
No.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, so now I have two motions. One is a motion to return property, and it's the defendant's passport.
Judge, that was gonna be used as evidence in this case. That's why the state was not gonna agree to it, but at this point, since he's taken a plea, we're not gonna propose that.
Okay, so that's agreed to. All right, then the next thing we have is motion to allow the defendant to travel. And he wants to travel. His son has an appointment in Colombia in April for hernia repair.
Judge, we leave that at the discretion of the court.
All right, he's going to be gone April 15th through the 20th.
Yes, Your Honor, and I believe in the way it's drafted, so there's an attachment with the return flight. It's not, I
Yes.
did bring that today, so I apologize for that.
All right, so if you bring the attachment, then the court will allow him to travel, or do you have it with
May I
you?
present it to you, Your Honor?
Yes. Well, I mean, it shows his bookings, but does he have something saying that his son has a hernia repair appointment?
I do not have that with me today. Your
All
Honor.
right, once you all receive that, then and present it, then the court will grant it.
Thank you, Judge. We'll reapproach.
All right, thank you.
May we be excused?
You'll need to speak with probation, then you're excused.
Thank you, Judge.
You're welcome.
Thank you. You're welcome.
All right, are the parties here on Ayala? Court is calling 2022 CR 6548, State of Texas versus John Anthony Ayala. Could I have parties announced for the record for the state?
Zach Dunn for the state. Michael Collins, attorney for defendant, present and ready, Your Honor.
All right, and are you John Anthony Ayala?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same John Anthony Ayala who was placed on deferred adjudication in 2022 CR 6548 for the offense of indecency with a child contact on January 17th, 2023 for a period of 10 years? Is that you?
Yes, ma'am.
Right, state?
Your Honor, violated condition number 3, on or about the 22nd day of February, 2024. In Bexar County, Texas, the defendant, John Anthony Ayala, did then and there fail to obtain and keep gainful employment in a lawful occupation as directed by the court and or supervision officer in violation of condition number 22.
All right, is this on the amended?
Well, I think it may have been a cross-reference, Your Honor, but it should just be a violation of condition number 3, given that it was an employment-based.
All right, any objection to the state adding that it's not a violation of condition number 22, but a violation of condition number 3, counsel?
No.
All right, so how do you plead to a violation of condition number 3?
True.
All right, state,
And Your Honor, the state will waive and abandon the other.
any objections?
No, we don't.
Did you understand by pleading true to violation of condition number 3, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 3?
Yes, ma'am.
Court will find violation of condition number 3 true. Is there a proposed agreement?
There is, Your Honor.
All right, and what is the proposed agreement?
We agreed that my client would go to state ISF for 90 days, Your Honor, then return to the SOMU upon release. GPS for 1 year through Bexar County Jail work release, waive the fee. No internet accessible devices for duration of probation. No internet accessible devices for duration of probation. require haven for hope if homeless, and zero tolerance. He's not homeless, his mother has a place for him.
All right, so can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
John Anthony Ayala.
All right, why do you not have employment?
I had tried applying to different places, but I either got the runaround or they just never contacted me back. And his mom is present with proof of 2 places that he did apply, Your Honor.
All right. So we want ISF. What is probation's recommendation?
That is a recommendation.
John Anthony, All right, so he's pled true to not having employment. How is ISF going to help things, or are we doing ISF because there are other things in the motion that are not being addressed?
Yes, sir.
Okay. Thank you. All right, any objection to the court reading the court summary?
Oh, yeah.
Okay, after reading the court summary, my question is, why shouldn't he be revoked? And go to prison, because obviously he doesn't want to follow the rules.
Well, his information to me, Your Honor, is that as far as having other devices, said he didn't have them. His mom is here to say that he had a flip phone. It was not internet accessible, Your Honor.
Well, I mean, obviously, if they're saying that there's history of what he should not be viewing, whether it's a flip phone or not. I never had a flip phone, but obviously it's showing a history. Are we saying it's not showing a history?
We're not pleading to it.
Or is he saying are you saying his mom was in possession of pornography? So I don't understand why should you remain on probation? It appears as though you don't want to be on probation. I see what they're asking for and what their recommendation is for, but I just don't understand why you should continue to be on probation. So, do you wish to go to prison?
No, ma'am.
It appears that you do, though, by your actions.
Since being locked up, it's been a real wake-up experience for him, Your Honor. He's not been in this situation before.
I mean, he's looking at 20 years in prison.
Emphasize
I
it to
mean-
him, and yes, he
I think that should be a wake-up call.
understands where he's put himself, Your Honor.
Now, it's not child pornography, but it's saying it's pornography and you're not supposed to be viewing it. So the question becomes, is watching pornography worth 20 years of your life potentially?
No.
It seems that you think maybe it is because they're saying they admonish you on February 7th, 2023. And then they admonish you again on April 25th, 2023.
I could only think of one time when they.
No, they said that they admonished you on February 7th and April 25th. So your question becomes, is pornography worth going to prison over? Potentially. I keep an open mind, but you have a choice. Either you can watch pornography and potentially go to prison, or either you can not watch pornography. Do you understand?
Yes, ma'am.
So do you want to watch pornography and potentially go to prison or not watch it?
Not watch it, ma'am.
All right, probation, this is what you all are asking for? And state, this is what your agreement with?
I think the like lack of clear details with respect to the phone, and it had porn on it, but then they were watching it. It's not of a child nature. The state was okay, and and amenable to going through this and making it a last leg, what would otherwise be a very long journey for this individual.
All right, he's joined ISF Cognitive. Then he is to return to the sex offender unit. There's to be GPS until further notice. And that'll be partial for work only. Waive fees. That's what they put in the probation recommendation. And you're not to have any access to the internet. Or internet devices. Probation, is there anything else? Is there anything else you need from the court?
No.
All right. You better do better.
This one, I plan to, I have plans to reapply to different places where I was denied or never contacted again from the same constant contact with them
And not watch porn.
and not watch porn.
Okay. Thank you.
Excuse you.
Yes. Alex Caragia. I keep pronouncing that name differently every time. I'm sorry. Oh, we can take a break now. All right, we're going to take a short break.
Smoke a cigarette.
Yeah. Everyone, we're going to take a short break, and anything that you are planning to work out today, you need to have the paperwork to the clerk no later than 3:45. Otherwise, you're going to be recalled for a different date.
I have a drill. Down there on the ground. I just need to place this part of the tail light. It looks everything like it.
You know, I had that on all my trailers. I have a grease fitting set on
Michael.
outside, so I just. Yeah.
No, he hasn't approached yet, Judge. Not yet.
What are you gonna haul? You just want a jury. There you go.
Yeah. Okay.
Barrel race.
Yeah, exactly.
Right?
Yeah. Yeah.
We'll do something like Joe's. Michael. I see you back.
Yeah.
I see you back.
Southwest Floresville, yeah, Espinosa County, which is
Southeast.
southwest. You got Cuero, you got Gonzales.
Well, you know, China Grove, you got, Lavernia, you got, Canals in the southwest.
West, south.
Like on 87. China Grove, you got Stockdale, you got, what's that other side? Oh, that's west, we're going west, I'm going east. I'm sorry, I was going east.
Yeah, no, I thought the other way.
Oh, Castroville.
I think that's. Fine.
Kerrville, Comfort.
I had up there by y'all's, by y'all's place. What if there's any places up by Turbo there?
We're in between fellas. Yeah. Well, you know, originally, Stone was an area called Champion.
Used to be out at.
You're right.
Yeah. They were supposed to.
Yeah.
They were paid for it like 2 or 3 times.
Yeah, well, my dad's law firm, when it's similar.
Oh, really?
Started.
I tell you what.
Yeah.
They just, it was the 80s.
Yeah.
And then it just sort of.
And then that's no, I actually. Watch it.
But then, you know, that hill, that's a hill or champion. Then that's where they had one of the things.
Yeah, so I had 10 acres. Well, it was right below the dam when.
The big earth dam?
Yeah.
Yeah.
And so I sold it when everybody was in college. I was making some money.
Oh, that right now probably would.
Oh, yeah.
Well, you would play, had to pay taxes on it. So it might have been outside, of- yeah, you would have had to live on there and put a homestead on it pretty quick, like maybe an ag.
Yeah. But it was doing. Get you know, pretty much.
I bet.
CTV.
I live with my dad.
No.
Like, tell us that you did. Like, a couple of guys came to my dad and said, hey, there's some land out here off 604, let's go buy it. UTSA.
I have my story in Bandera, and they're in 1604.
Yeah.
I got about the corner. AG. I think it's.